Hello and welcome to Kevin's Corner. I am your host, Kevin Horner of Gallagher & Manning. Thank you for joining me this afternoon. I'm going to talk today about a topic that I think people see the headlines of and always just kind of scroll by in their mind. They just assume it doesn't affect them. But what I wanted to do was talk about disability planning in every estate planning for other people. What I mean by that is I know I talk about incapacity and how you deal with aging in your own estate plan. That comes up fairly frequently. People at least realize they have to confront that. But what I'm talking about is the possibility of doing planning for someone who's disabled, who is a beneficiary of your estate, or someone else who you take care of or routinely give things to, okay? Now, I'm not going to go through all the specifics of this, but a lot of times when you have a beneficiary who has a disability, especially if it's a long-term one, maybe had it from birth or at least young age, is they're relying upon government benefits for something in their lives, be it housing, basic support, medical needs, and so on. A lot of those programs, when you're in that situation, have a means-tested component. Essentially, if you do have money or income, you're supposed to pay for things yourself, and the government doesn't do so. So a lot of times when you're benefiting an individual like that, you try to leave everything to them in a certain style of trust, typically called a supplemental needs trust, that enables them to benefit from the money you leave them without kicking them off the benefit. So what I want to talk about today is 4 common places that everyone needs to be thinking about this, even if you don't believe, or at least currently your beneficiaries don't have a disability, okay? So let's start with the easiest one. Everyone assumes this doesn't apply to them because they think I'm just going to give it outright to a sibling, a spouse, a child, grandchild, whatever, and they assume that will be just fine. There's no known disability. What a good estate planner can do for you, and we do this all the time in our planning, is have at least what's called a contingent trust, a trust that will catch property if the beneficiary is disabled and can't receive it themselves. Now, I'm thinking right now about disability as in they're not have the mental capacity to do so, they're legally incompetent, but it could be even an age of minority. They could be 16, not legally able to take title to property. And so I've had this conversation with a lot of clients recently about why this is even important, is even if you're expecting just to give everything outright to a beneficiary, you might have a situation where that's actually harms the beneficiary, or they simply can't receive it, and then you have a trustee or an executor on the hook in your estate not knowing what to do because they have no way of finishing their job, all right? And it ends up leading to bad consequences, certainly a lot of frustration, and is certainly very fixable. In a worst case scenario, that money is already attributed to the disabled beneficiary and they lose the government benefits no matter what. So a really easy thing is just to work with a good estate planner who can have at least that, maybe not the full robust powers, but at least a contingent trust to help protect you if some disabled or someone of your beneficiaries should become disabled in the future. So that's one. Think about contingent trusts. 2, think about how your powers of attorney are done with regards to gifting in particular. Now, by this, what I mean is if you already are gifting or supporting an individual, all right, maybe already with disabilities, maybe not. A lot of times I see this come up with elderly parents. This is actually going to bleed into number 3. But sometimes, just simply put the way it is now, there's a lot of adult caregivers who provide care to their elderly parents or loved ones, both physically and financially. And so whereas right now you might be offering the money free and clear, maybe at some point it makes sense, either through your gifting or in your own estate plan, to set everything up for them in a supplemental needs trust so that the elderly individuals can use government benefits. What are we talking about there? We're talking about Medicaid. We're talking about long-term care benefits. So I sort of mixed 2 and 3, but 2 is going to be you might want to have a power of attorney that enables your agent to continue that gifting, but not just outright, but to set up a trust that's going to protect the disability of the beneficiary while still being able to support them. And then number 3, I already kind of gave it away, is a lot of people anymore, because they are taking care of their parents, have their parents as beneficiaries of their estate plans, which is certainly perfectly fine. If you are doing it though, we do this frequently, is you might want to consider leaving it to them in a supplemental needs trust, at least a contingent one, because there's a good chance, especially if you're going to support them or if you were supporting them, that they may need to use long-term care benefits, in which case that money will be lost if they were otherwise going to be using Medicaid and it could kick them off the benefits, or it'll have to spend it down immediately. So that's a good commonplace that comes up. People aren't anticipating, but frequently is important to do. And then fourth is actually one that people tend not to think about, so everyone imagine can happen to them, let alone to their spouse, is that in that same context of long-term care planning, whereas you can do gifting for other individuals in a way that may not affect their government benefits, depending on all the circumstances, of course, or you might be able to set up something for their benefit they have no right to, okay? Something that will not affect their benefits, but it's a benefit you're providing. When it comes to spouses, the only way you can really do that, because all the government benefits are essentially federally backed, and they look at the joint assets of the married couple for this. The one kind of exception to that is if one spouse passes away, and it has to be testamentary, has to be through an estate, but leaves a supplemental needs trust in their estate for the benefit of their spouse. So instead of just simply saying what most people were thinking of, I have roughly this half, spouse has roughly this half, when I die it's just going to all go together. Sometimes it's a good idea to not do it that way, and instead have a disability-based trust, SNT, in between the two. So whatever you're leaving the spouse, it still can benefit them, but if they end up needing a long-term care stay, a Medicaid stay, a nursing home stay, then whatever you left is not going to count for those purposes, okay? So that's one that people, like I said, they tend not to think about it, but once they're there, or at least once one spouse is there, using a long-term stay or anticipating a long-term stay, it's certainly worth considering, if nothing else. And it requires a little more work than some other estate plans do, but if you're there, it's worth it. So those are the four. It's to think about contingent trusts for beneficiaries that may become disabled in the future. 2, to use powers of attorney that allow gifting not just outright, but in the form of trusts, so you can protect the beneficiaries in that context. 3, think about it with elderly parents, especially people who might need long-term care. You're not thinking of them as disabled, but they might need a government benefit for their care, like Medicaid. And then 4, between spouses, again, if someone's going to use long-term care, you may or may not want to leave everything in a supplemental needs trust for the benefit of the other spouse. So that's 4, and I say those 4 because it comes up all the time. Frequently in reviewing trusts or wills that we draft, we'll have some of these issues raised, and clients will think this is not, I just want to keep this as simple as possible. I just want to give it outright, and that's perfectly fine, and that can work. But I've had more than a few cases that have gone maybe not the way I wanted because that wasn't there, or I didn't do the estate plan, and it ended up leading to a bad result the client clearly never wanted, just no one thought it was going to happen. So those are 4 very common things you should think about with regards to disability planning for your beneficiaries in your estate plan. So with that, I want to say thank you very much. I think next week we'll probably be talking about some tax topics, which should be a lot of fun for everyone, I'm sure. If you do have any questions or any topics you want me to cover, by all means, either you can make a comment or send in a message. Our website is galliganmanning.com, so you can get it through that portal. I thank you all very much, and I will see you again next week for